done by the CIA for a long time. It was thought that they just tried to do it.
Well, good morning, ladies and gentlemen. I'm delighted you're all here. I'd like to welcome you all to the Institute of World Politics, and we are honored to have a very special guest here today, General Mark Martins, who is going to be discussing a fascinating issue which deals with actually some of the classic policy questions concerning the conflict between our constitutional liberties and our national security. And this has to do with the effectiveness and the legitimacy of military tribunals for the prosecution of insurgents and terrorists who have been captured as irregular forces out of uniform on the battlefield. People who, by presenting themselves in such a fashion, have not particularly conformed with the laws of war, the international laws of war, and therefore who have put themselves in a certain kind of a jeopardy when it comes to the nature of how we go about prosecuting them. Nevertheless, there is an abiding interest in the United States in ensuring that there is justice that is meted out for all, including the exoneration of those who may indeed be innocent. But we also have the problem of trying to maintain the effectiveness of our national security and the protection of classified information. And so this is a policy issue which our government has wrestled with over the past several years. There's been a Supreme Court decision about this. There has been legislation, and more recently the President himself has been involved in ensuring that military tribunals are indeed a legitimate way to go when it comes to handling insurgents and terrorists of this type. And so we have today one of the premier authorities in the United States government addressing this issue, General Mark Martins, who is Chief Prosecutor of the Military Commissions. He became it was last September that he became the Chief Prosecutor. In the previous year in Afghanistan, he was commander of the Rule of Law Field Force, Afghanistan, and had a dual hat role also in the NATO Rule of Law Field Support Mission. The prior year, also in Afghanistan, he had served as the first and interim commander of Joint Task Force 435, and then was its first deputy commander upon Senate confirmation of Vice Admiral Robert Hayward. In these roles, Brigadier General Martins led the effort to reform U.S. detention operations in Afghanistan and provided field support to Afghan and international civilian rule of law project teams in contested provinces in the country. Prior to his deployment to Afghanistan, he co-led the interagency detention policy task force created by the President Obama in January of 2009. General Martins has an extremely distinguished career and background prior to these deployments in the war zone. He graduated first in the Order of Merit from West Point in 1983. He served as a platoon leader and staff officer in the 82nd Airborne. He became a judge advocate and served in a number of legal and non-legal positions. He's been deployed to zones of armed conflict for more than 5 years, including service as Chief of Staff of the U.S. Kosovo Force, staff judge advocate for the 1st Armored Division, and then the multinational force Iraq. He was a Rhodes Scholar, graduating with first honors, a graduate of Harvard Law School, magna cum laude. He also holds an LLM in military law and a master's in national security strategy. He has numerous awards, including the Defense Superior Service Medal, the NATO Meritorious Service Medal, the Department of State Meritorious Honor Award, the Legion of Merit, the Bronze Star, was it twice, the Army Meritorious Service Medal, and others. So it is a great pleasure and an honor to have you, General, to join us and to speak with some authority, with great authority, about these matters. Welcome to the Institute.
Well, thank you, John, for those generous remarks. Great to be in this historic building with this esteemed institute, having a conversation today about reformed military commissions and the challenge and the project of legitimating that institution, which I believe is a very important institution for our national security and our entire justice process. And as John, the President here mentioned, there is a challenge in balancing imperatives of national security and the implementation of the rule of law. He mentioned that I was an infantry lieutenant in the 82nd. I just got back from West Texas. I was out in Texas Tech Law School. I've been trying to make some time to get out to different venues to talk a little bit about military commissions. Was out teaching some classes for a former Judge Advocate General of the Army, Walt Huffman, who's out at Texas Tech Law School now in Lubbock. And it brought back to memory my time there as a lieutenant with my platoon sergeant, Sergeant First Class Smiley. We were out in a field exercise all day one day in the hot Texas sun. And it was a little after midnight when we finally got to bed beside our foxholes. Have this grizzled two-time Vietnam War veteran next to me, airborne Sergeant First Class, and I'm a green infantry lieutenant. We go to sleep. 2 hours later, I'm getting nudged by Sergeant Smiley. He says, "Sir, look up in the sky. Tell me what you see." I looked up in the sky. I saw this, heaven full of West Texas sky. And I said, "Oh, I see a heaven full of stars, platoon sergeant." He says, "Sir, what does that tell you?" I said, wasn't really sure where he was going with the question. So I said, and I did want to impress him. So I said, "Well, Sergeant First Class, astronomically it tells me there are billions of stars and hundreds of billions of planets. Some of them may have life on them. Theologically it tells me that we are but small and insignificant and God is great. Meteorologically it tells me that with a clear sky we're going to have a great day of training tomorrow." Pause, thinking that I had overwhelmed him with this profound response. What does it tell you, platoon sergeant?" "Sir, it tells me that somebody stole our tent." That was the last time I really set out to try to be profound. It was a good grounding moment of the kind you can only get in the airborne infantry. Let me talk a little bit about military commissions. We are dealing here with an institution that in its previous two iterations were flawed. They were flawed. We've worked hard on reforms and believe strongly that these military commissions can be fair and can do justice. I'll talk a little bit about some of the procedural protections with some emphasis on the reforms that have come in the 2009 Military Commissions Act. And then I'll talk about some of the actors in this system, some of the officials, because it's very comparable in a lot of ways to court systems that you know about, but worthwhile to talk a little bit about some of the different officials in the system. And then I'll raise several, just to get you thinking so we can start the conversation and maybe you'll be warmed up. I'll raise some of the criticisms and what I believe are now decisive counters to those criticisms. Okay, so military commissions. In military commissions, an accused is presumed innocent. The prosecution must prove the accused's guilt beyond a reasonable doubt on specified elements of offenses. The accused is to be provided notice in writing. The charges have to be written down of what he's charged with. An accused has a right to legal counsel and a choice of counsel. Any accused facing an offense for which the death penalty is authorized by Congress receives counsel at government expense. and someone who has experience in death penalty matters, so-called learned counsel under the statute. An accused may not be required to self-incriminate, right against self-incrimination. There is a right against the introduction of statements obtained as a result of torture or cruel, inhuman, or degrading treatment. And the standard of admissibility for statements of an accused is voluntariness. Under the 2000, this is one of the areas that's an important reform of the 2009 Act. An accused has the right to see all of the evidence the government's going to present. This is discovery. You're familiar with this in our criminal civilian legal system. That's fairness. You got to see what the proof is of the government. You got to be able to confront it meaningfully, confront that and challenge that as, that evidence. You have the right to cross-examine the government's witnesses. An accused has the right to compel, using the authority of the government, witnesses on his behalf. They have to appear in order, if the court has jurisdiction, the ability to compel anybody for the government, same is available to the accused to compel witnesses in his behalf. The accused is protected by exclusionary rules of evidence that prohibit the introduction of information that is overly prejudicial or not probative, or would otherwise be fruit of a poisonous tree. Different types of exclusionary rules that, again, are similar to those in civilian criminal practice. Protection against double jeopardy. Can't be twice put in jeopardy of life or limb for the same charges. Protection has a right to represent himself if he is competent and if he has been very clearly put on notice of the right to counsel and his opportunities. You can't be forced to be represented by a lawyer. And a right of appeal upon conviction to a court of review, military commission court of review that Congress established in the Act, as well as the federal district court or federal appellate court for the District of Columbia Circuit, federal circuit court. So it goes through the federal system, our Article 3 federal courts, to the Supreme Court. So it's a broad, comprehensive body of protections, and I've merely just summarized some of them. And with the reforms in the 2009 Act, prominently including the prohibition on the introduction of cruel, inhuman, degrading treatment, statements obtained as a result of cruel, inhuman, degrading treatment, and a modification of hearsay rule. There is a slightly broader aperture for the introduction of hearsay evidence than in a federal civilian court, because a judge is put on notice by the statute to take into consideration operational and intelligence factors that involve the collection of evidence on a battlefield, where you may not have the ability to bring all the evidence into court because the place where the crime occurred or where the individual was captured or arrested is beyond the jurisdiction of the court in a faraway place. There are hearsay exceptions in our civilian criminal court that allow for the introduction of hearsay. This is an out-of-court statement offered. So you don't bring the witness into court, but you offer a document or somebody telling you what someone else said. These things are disfavored. They don't tend to be brought into court because you want, again, the accused to be able to confront and cross-examine the witnesses against him. So our law, Anglo-American law, disfavors hearsay. Many legal systems do. Hearsay exceptions exist, though, when you have a type of out-of-court statement that is, it has inherent reliability. There may be indicators within it that make it more reliable. It's a regularly produced business record, or it's a dying declaration of somebody. The declarant is no longer available, but he made a comment that has some historical indicators that it may be reliable. And it's introduced for a certain purpose at trial. Military commissions allow for a slightly broader aperture of hearsay for the things that operational reasons, battlefield exigencies where evidence tends to disappear, would make it in the interests of justice to allow the introduction of probative, that means it provides proof of something, relevant, it's material, it deals with the issues at hand in the court, and lawfully obtained. It has to have been obtained through lawful operations of forces. So again, a statement, an out-of-court statement obtained as a result of cruel, inhuman, degrading treatment would not be admissible under this rule. The 2009 Act narrowed, although it's still a slightly larger aperture for hearsay than you would find in federal criminal court, it did narrow the standard that was there in the 2006 Military Commissions Act by requiring the party, either the prosecution or the defense, that was offering the hearsay to establish its reliability. Previously, it had been flipped, so it was the challenging party had to establish why something was, that the moving party, the introducing party, was offering was unreliable. And I think that's a significant change as well in the direction of fairness. Congress, another important reform is Congress wrote in the 2009 Military Commissions Act the sense of Congress that the resourcing of the defense function in Guantanamo was important to the legitimacy of the tribunals and that they should be resourced. It also stated that the opportunity of an accused to obtain witnesses and evidence shall be comparable to that in an Article 3 federal civilian court. So this notion of resourcing the defense and ensuring they have the ability and the wherewithal to mount a defense and to test the evidence, this was, and form a relationship with a counsel, competent counsel. This was something that the court, or that the 2009 Military Commissions Act and Congress felt strongly about. And then another reform, and the President here mentioned this in passing, classified information procedures. The 2009 Act incorporated the Classified Information Procedures Act that is used in federal court. So and this goes to the balance that he also spoke of between national security and the insurance of our cherished civil liberties and how we do things as a country and commitment to the rule of law, that we are going to both protect our secrets. There really are secrets. There are sources and methods of intelligence that help protect us from future attacks that could be compromised if they were brought out in open court. Troop movements, methods and ways in which these ununiformed, irregular forces operating in the shadows of international boundaries, disguised as civilians, so they're not in a uniform, carrying arms openly and operating in accordance with the law of war. Information about how they're operating, how they're using new off-the-shelf technologies that are so powerful and give them such capabilities that they didn't have before. Ways in which to track them down really could harm the public interest and the national security. So the Classified Information Procedures Act Congress first passed in 1980 for the federal civilian system, which gives a judge tools in order to ensure that the accused has the right to challenge the evidence the prosecution is bringing. This is that discovery right that I talked about. It's key to our system, right? You can't just be convicted if you haven't had a chance to test the evidence. But to require that either the prosecution or the defense, if it's going to introduce classified evidence, that it put the court on notice in advance and give the court and the parties an opportunity to figure out how to reconcile those sometimes conflicting interests, that of allowing confrontation, which is necessary in order for us to have a fair trial and get accountability under law for crimes, so that law enforcement, if you will, interest and the national security interest, protect the the classified information. And the Classified Information Procedures Act, CSPA, of 1980, says to the judge, figure out how to do both wherever you can. And there really are ways to do it. You can summarize the evidence in a way. You can have an excerpt of a document that protects the sources and methods but ensures that the accused sees what the part of it that is condemning him or inculpating him gets to be reviewed and tested. And this has been in operation in the federal courts since 1980. There are a lot of cases. It gets, a lot of litigation over it because these balancing things are things that require judgment. But it's a body of law that is now well established. The 2009 Military Commissions Act took advantage of the fact that the federal courts had been using this since 1980 and incorporated it almost entirely. What it did is incorporated it and then enshrined into codified law the judicial changes to CSPA or interpretations to the Classified Information Procedures Act of 1980 that have happened since 1980. So we have federal classified information procedures in our military commissions that protect our national secrets, but also ensure that we can, with a full, fair trial process, hold people accountable under law. So those are the major reforms, the protections. Let me talk a little bit about who is part of a military commission. Well, I'll start with me. I'm a prosecutor, very much in the tradition of a public prosecutor in the United States legal tradition. Represent the government in the prosecution of alleged criminals. Has a lot of discretion associated with it. You have to decide what to charge, who to charge, whom to charge within your jurisdiction. You have to figure out, do you perhaps talk to somebody about an offer to plead guilty such that he can cooperate with someone else? You've got to determine which issues on appeal may be raised. There's a large amount of discretion. Well-tilled soil here in discussion of the prosecutorial function and why we have it in our system. And we have it because you need to give judgment calls to particular prosecutors to determine what are the most serious and beneficial prosecutions to bring. What comes with that, though, is a great responsibility with all that discretion. We don't give that kind of discretion out unless it's for the purpose of doing justice. So there's a strong doctrine of public prosecution, which means that we're officers of the court. We're not just seeking to win at all costs. We're trying to see that justice is done. And that's an important part of our tradition. Actually, a couple of 100 years ago in the United States, we had a tradition coexisting with that of private prosecution. Private parties would be non-governmental, non-state actors would actually prosecute the case before the court. And this has been supplanted through the 19th century and currently with this public prosecution doctrine, which requires that prosecutors turn over exculpatory evidence. This is another right that accused have. If we find something that makes an accused look less guilty, or tends to show that if he is guilty, that he's less should be punished with lesser punishment, that's something we have an affirmative and continuing obligation to turn over. So that's the prosecutor. In many ways, the engine of the system gets it going, starts it by charging the individual, and is subject to this public prosecution ethic that I've talked about. There is an official known as the convening authority. And the convening authority has a number of functions. I'll analogize it to federal civilian legal practice and legal practice that you may be familiar with in state courts. The convening authority does serve a grand jury function, a testing function. Once I have endorsed charges against somebody and say these are violations of our code of crimes, Congress has codified 32 crimes that are violations of the law of war. I see that they are charges and that we have the evidence against all of the elements of the offense, I then forward them to the convening authority, who is an official who has to separately, with legal advice, he has very competent counsel, he's supposed to look at them independently and determine if he agrees with that. If he does, he will then refer, is the term, he will refer the charges to a military commission for trial. So convening authority in the function I just described functions something like a grand jury. It's oversimplistic to just say it is the grand jury for our system because he has other duties, which include actually assembling that commission, and I'll talk about that in a minute. And then he has a clemency function on the other end if there is a conviction. He gets to see whether or not clemency is warranted after the commission has done its sentencing job. So that's the convening authority. This is very similar to any of you who are in the military justice system, which is under our Uniform Code of Military Justice of 1950 and subsequent legislation that created our courts martial for prosecuting our soldiers, sailors, airmen, Marines who have violated the Uniform Code of Military Justice. The convening authority in that system, also a military justice system, is a commander. So the convening authority in military commissions is not a commander. He's actually retired at this right now, retired Vice Admiral Bruce McDonald, highly regarded former Judge Advocate General of the Navy, is serving in this convening authority function. Okay, so you have this convening authority. The convening authority also selects a jury. So there is a jury now that is the heart of the commission then that receives the referred charges. The military commission is composed of Army officers, active duty military officers, active duty military officers. So there's a jury pool, if you will, of about 230,000 officers who serve worldwide from all 50 states. Impressively diverse, monitored for diversity by our Congress, because the Congress isn't going to let its military become a separate caste. And there's a specific attention paid each year to how representative this pool is. It's not perfectly representative, but again, I would submit to you, impressively representative. They differ also from a civilian jury that is chosen under our Sixth Amendment in a civilian trial randomly out of a jury wheel from the district wherein a crime will have been committed under the Sixth Amendment. Differs from that jury in that they tend to be a little bit younger than a jury and a random juror that would be picked in a location. They are college graduates because they're all officers. They've self-selected for service worldwide. But they're not a random jury and a civilian jury. And this is an important distinction between the systems. They do the jury function, right? This is a central institution of our criminal justice and our democracy that connects our government to the people is the jury. And it holds that we have to have an impartial fact finder that is going to look at this case. Not somebody who deals with these things all the time. An impartial fact finder is going to come essentially cold to the case, not know the accused, not know the charges, can be challenged off if they're too close to the charge or have some kind of bias. So it's the same notion of the jury trial, and in fact, historians have found that the military jury first arose in Britain's first Mutiny Act in the 17th century, and it had 13 was the number, 13 members, and it was modeled after, consciously, the common law jury of Britain, which was 12 jurors and then a judge, or 12 jurymen and a judge. So this is a tradition that is also part of our Anglo-American military legal tradition, is this notion of the jury, of assembling people to look at the facts of a case. And the basic function of a jury is to test those facts and look at them, find out what happened. You all remember John Adams defending the British redcoats who were alleged to have massacred Bostonians in Boston, right? John Adams tells he's a patriot, future U.S. patriot, who is now defending British soldiers. And he says famously to them, "Facts are stubborn things. Jurors, facts are stubborn. Whatever your passions say, whatever your desires might think, facts have weight. You can't push aside." That's the heart of a jury function, is to test those facts in an impartial way. And that's very much part of the military commission process, with these differences, not randomly chosen. And then the convening authority that I mentioned has the obligation to select jury members. And by statute, he's required to select them on the basis of age, education, training, experience, length of service, and judicial temperament. And having been a convening authority, having also been a juror when I was an infantryman, serving with Sergeant Smiley, I got tagged for jury duty as an infantryman. And then I've been a staff judge advocate and a trial counsel and worked with a lot of military juries. They are selected with an awareness of the importance of diversity in a jury panel. You want to have, the classic American theatrical example of this is 12 Angry Men, right? I mean, you've got people who are looking at the facts from a lot of different ways. There's a lot of power in that model, even though scholars who've looked at 12 Angry Men have said, hey, wait a minute, those are 12 angry white males. That's not particularly diverse in some ways. Nancy Gertner, great judge up in Massachusetts, wrote some really good articles about this. But nevertheless, diverse in their life experiences, and you have different people coming at the same sorts of facts they heard about at trial and testing them from different angles. Important part of our jurisprudence and our system. That's the heart of the military justice system as well, and the military commission system, is this jury, in this case of officers, like Khalil Tawil here, Lebanese-American, two-time Afghanistan veteran, studied in Cairo. I mean, we got a diverse group of people that the convening authority selects 12 from to test those facts. Okay, so I've spent a little bit of time on it. That's worth it, because the jury is a really key piece of this. Then there's a judge. There's a presiding judge over this. This is an experienced attorney, someone who's graduated from a law school and is practicing before the bar of admitted before the bar of one of the states. And he is typically an Army colonel or a Navy captain, Air Force colonel, typically a senior officer who has significant experience and training in criminal law. And they are judge advocates. They are legally trained officers, certified and qualified. They are not, another important distinction, they are not Article III judges. So these are not lifetime tenured judges who have been chosen, nominated by the President and confirmed by the Senate, as our federal and appellate and Supreme Court judges are. But they are, I would submit to you, independent. And if you look at their decisions and the things they have done to date, I would defy you to say they are somehow carrying out the will of somebody else. They are doing the law, and they are experienced in doing that. So those are the different players in the system. Then what they do is try the charges, the referred charges, ensuring that all of those protections and procedures that I talked about, that are the protections of the accused, happen. It looks like a trial that you will see in a civilian world, if you've ever been on a jury or been in a trial. Prosecution will, both parties will make opening statements, tell the jury what the evidence will show. The prosecution presents its case in chief, providing evidence, direct testimony, bringing in different types of evidence, forensic, physical evidence, demonstrative evidence it's called, charts and things to try to explain complex data. And then all those witnesses, expert testimony if something's really technical. And then all those witnesses, the accused counsel will cross-examine, have the opportunity to cross-examine. Prosecution will rest. Typically, a defense will make a motion for a finding of not guilty right then, but even before going to their case. Your Honor, the prosecution hasn't proven guilt beyond a reasonable doubt. That is their burden. because at that motion stage in all systems in Anglo-American jurisprudence is one where you consider in the light most favorable to the prosecution for that purpose. If there is enough on particular charges, that motion will be in that case denied as to particular charges where it's not true or where they have proven it. Defense then presents its entire case, brings forth all of its witnesses to show not guilt, that an individual is not guilty. The prosecution will cross-examine those witnesses. This is all happening in front of this jury, right? Judge will then give instructions to the jury on the law, on how they are to do their proceedings. Both parties will give closing argument, explain why. This is an adversarial system, right? This is an adversarial system. Test the prosecution's evidence in the most rigorous procedure known to our law. That's what this is intended to do. So you have confidence. And that people who weren't watching it can say, okay, I know those procedures were used, so I have confidence that those 12 people who were in that room and had listened to all the evidence and heard the contest of ideas and facts and law, that I trust that. I trust that. I should have mentioned, by the way, too, the jury, there is a peremptory challenge on the jury. So even if you don't have a causal challenge, that someone knew the accused or has some other bias, there's a peremptory challenge that you don't have to give your reason. Although military juries do use doctrines in civilian jurisprudence with regard to peremptory challenges. If you're familiar with Batson v. Kentucky, this is the doctrine where if someone is challenging off a member for an invidious reason and discriminatory reason, Batson is a party challenges off a black member of the jury because the individual is black. That is against the doctrine in Batson v. Kentucky, and that's also observed in military courts as well. So peremptory challenges are a part of assembling this jury pool. So then the jury deliberates, and you wind up getting a verdict, and then sentencing happens if there is a finding of guilt on any count, and that is preceded by, again, an adversarial process where both sides are presenting witnesses as to aggravation or extenuation and mitigation, and then you have a sentencing process that, again, where the jury does the sentencing. So I wanted to spend a little bit of time on that. Okay, now before I go to questions, let me maybe trigger some questions by raising criticisms of the system and then giving you a sense of the counters that I believe are persuasive, but sort of starting the conversation. I call them the 5 uns. There are five uns that are summarize the criticisms of military commissions. That they are unsettled, unfair, unnecessary, unknown, and or unbounded. And let me go through those 5 uns. Because I believe that although some of them had aspects that were sound, criticisms at various points in the prior versions, now they are either untrue or misleading. And that to continue to oppose the military commissions that I've summarized and described after 2 different administrations in the executive branch, the Supreme Court in the Hamdan v. Rumsfeld case, which although it invalidated the 2001 version of commissions, made very clear that Congress had the ability to make commissions. And then no less than 5 acts of Congress have established a strong basis for these commissions to continue to oppose them when considering how justice delayed at some point really does become justice denied. To continue to oppose that framework of the rule of law at this point is my final unwise. Okay, so let me go back to unsettled, unfair, unnecessary, unknown, unbounded. Okay, the argument that military commissions are unsettled is that you're having to make this stuff up as you go along. There aren't really any settled procedures. It's all changing. And that there's so much litigation risk. People are just going to be challenging it forever, and you're never going to really get to where you're going. And they'll point to the fact that there have been 7 convictions by military commissions. And there have been over a couple of hundred comparable international terrorism prosecutions by federal criminal court. So it's unsettled. Why use these commissions? Unsettled. To that I will say that there is well-established law these commissions are providing. And I would ask you to try to view these or look at the transcripts online. I'll talk a little bit more about the ability to do that. But a judge operating in this system has law, has sources of law. He is to look to courts martial with some minor differences. I spoke about this hearsay thing, the hearsay aperture being slightly narrower. There are also no Miranda rule, no requirement for warnings to be read, which is a different. But with some very isolated differences, the Uniform Code of Military Justice and all of the judicial decisions in military courts are applicable. He looks there. The judge also, he or she, will look to federal law. There are specific places. I mentioned Classified Information Procedures Act is an area where we draw heavily from federal law, but there are others. This area of what has the accused been given the opportunity to obtain witnesses and evidence, and some of the discovery rules. There's a place to go for law. This idea that there's no sources of law or that you have to make it up. I submit to you, that's a court is about applying law to an individual case. So there are issues that arise. They arise all the time in trials. That's what our system does. So judges are having to resolve cases, individual cases, by applying law to individual facts of an alleged crime. But that's no different than you have in any other system. And the system is built and set up to tee up, to raise these issues for methodical and reasoned resolution in a methodical way. And it's happening. It's happening. So this idea that there's this enormous litigation risk is increasingly dissipating as we get judicial decisions. There are 2 cases. I'm not going to say there aren't continuing issues. There are in every system. Big issues that we have include the offenses of conspiracy and material support for terrorism. These are challenged very fundamentally and substantially by parties. They're going to be heard by the D.C. Court of Appeals here very soon in early May. There's going to be an oral argument, and they're considering that on the appeals of Salim Ahmed Hamdan, one of the convicted accused. So I would counter that it isn't unsettled. It is a settled body of law that's being applied. That they are unfair. Now this goes to one or more of those protections that I gave you, that somehow they aren't fair enough. And I've listed all of them, won't list them again, but I will say that this is a body of procedure and law that will produce fair trials. And that those latest reforms, the reform not to admit any statement obtained as a result of torture or cruel and inhuman degrading treatment, is an important one. But that these are fair trials administered by independent people who are not waking up in the morning trying to convict somebody. I mean, these are all independent officers who have, although again, not tenured positions for lifetime within our federal system, are independent, fair, sworn to uphold the Constitution, and are doing their duty. So, response to the unfair criticism. Unnecessary. Now this is somewhat related to that unsettled one that I mentioned. We have a system. I am a big fan of civilian trials for international. Our U.S. attorneys' offices in a number of districts have done a great job in doing this. And there are, I would say that most cases where you have an overlap in jurisdiction, and let me pause to explain that a minute, because it's at the key of this unnecessary argument. Military commissions try alleged violators of the law of war. And they must have jurisdiction 3 different ways. there has to be a violation of the law of war. It has to be a crime against the laws of war. So a subject matter, it's not, you can't try somebody in a military commission for violating a financial law, right? I mean, it has to be a crime. Some of these things are similar to what happened in peacetime, murder, but happening in the context of hostilities. I'll talk about that a little bit more in a minute. Some of them look very much like crimes in a criminal code, but some of them don't, right? Perfidy and treachery. These are illegal means of warfare. Using perfidy, classic use of perfidy is, you're in a vehicle with a Red Cross on it, hiding behind the protection that the International Committee of the Red Cross may get on a battlefield, and you fire from that vehicle. That's an act of treachery or perfidy. You're using your enemy's reverence for the law or obedience to the law as a weapon. That's a perfidious crime under the law of armed conflict. So you have this body of 32 crimes. You have to have jurisdiction. You can only charge those. You have to do it over somebody who is the right kind of person to charge. And this is a unprivileged belligerent. An unprivileged belligerent, somebody who is not complying with the laws of war. So you can't try an enemy prisoner of war, somebody who's a uniformed enemy in a military commission convened under the Military Commissions Act. Congress has said these are limited to unprivileged belligerents. And then finally, it has to be in the context of and associated with hostilities. So hostilities are more than sporadic acts of violence. This is concerted, protracted armed violence of a scope and an intensity that justify the use of the armed forces to counter. And this is a narrow jurisdiction. Now, if you look hard at some of these things, murder in violation of the law of war, conspiracy with others to commit murder in violation of the law of war, attacking civilians, hijacking of aircraft, these other things that happen in the context of hostilities, if you look at that and say, hey, that looks like a civilian crime too. We've got hijacking statutes. We've got terrorism statutes. You're right. There's an overlap in jurisdiction. That's the nature of the world we're in. It's the nature of the threats we're facing, is that they can be characterized both as a violation of civil law and civilian laws and a violation of the law of armed conflict. We've been in a no-kidding armed conflict with al-Qaeda and associated forces. And one of the key indicators of that is Congress in 2001 passed an authorization for the use of military force, which made it very clear that al-Qaeda and associated forces and those immediately harboring it are enemy. So you've got this overlap in jurisdiction. The unnecessary criticism is, hey, why don't you just try all those people by civilian court? And the response to this is that although I believe that is in our interest most of the time to do it, there is a narrow category of cases where the best choice is a military commission. And there's a variety of different arguments I will give you on that basis. But some of them boil down to how the crime ought to be characterized. What is the best way to punish and characterize that criminal conduct? What is either war criminal conduct or civilian criminal conduct? Sometimes it's better to characterize it as a violation of the law of war. Sometimes it is an offense that, although on the books in the federal courts, because there has been a War Crimes Act that allows federal courts to punish war crimes, has never been tried there. So this is sort of an inverse version of the unsettled. They have not tried these kinds of cases. They've not traditionally been used. Others might emphasize the difference in the jury. We certainly want our civilian juries to handle international terrorism cases. The jury is one of the ways our society gets skin in the game in a prosecution. It causes the people to have to consider a crime. So in New York, Southern District of New York, and Manhattan, Alexandria, jurors having to consider these threats and whether or not a crime has been committed is a very healthy part of our process. However, in a particular case-intensive analysis of where a case should go, sometimes a military commission is the better choice to use that jury that I described. or to use it in an area that maybe isn't a downtown area. Again, I believe our cities can handle international terrorism cases, but there are situations in which you put these factors together. Another happens to be, whether or not Miranda warnings were given, and is that the right rule for the circumstance? Miranda makes a lot of sense if you're insuring against self-incriminatory statements in the streets of Chicago. Given it in Kandahar, where Khalil Tawil and I were this time last year, it makes no sense at all to have 18, 19-year-old troops given Miranda warnings. That can play into a question of whether or not you go with a military commission. So, and I mentioned the hearsay rule before. So sometimes these differences in the proceedings will make military commissions the wiser choice. And that is the counter to the unnecessary argument. Because when you're faced with this kind of threat, not an existential threat, I'm not going to compare it to what we were facing in World War II, when 130,000 humans died in the Battle of Okinawa alone in the South Pacific. Different kind of order of magnitude kind of threat. But when you're faced with a serious threat, and a threat that defines us in how we respond to it, changing, and that involves new technologies and new ways these groups are going to be coming at us, and in fact groups that both flout the law and cynically invoke the law for refuge. When you're dealing with threats like that and they're out there, why would any government take an institution or a tool off the table? This is the counter to the unnecessary argument. Flip it around. Why would we take that off the table? This is a system that military commissions that has been around in some form or another since before the Constitution. Again, two administrations now have said it ought to be part of our national security apparatus. So that's the start of a counter to the unnecessary argument. You may want to follow up on it. Unknown. Hey, okay, you're persuading me, Mark Martins, that there is these can be fair, but I don't know anything about them. I don't know them. I haven't seen any of them. I don't understand them. They're unknown. And isn't that a part of being perceived to be fair and being known to be fair? And the history of an institution is an important thing to consider. I would agree with that. But I would say that we've made important strides in helping them be known. Because these are taking place right now, although they don't have to be, but they're taking place in Guantanamo. And nothing in the Military Commissions Act mentions Guantanamo, by the way. I mean, they're not specific to any particular site. They can be convened elsewhere. But they're happening in Guantanamo now. In order to ensure people understand and can see the proceedings, they are being transmitted by closed-circuit television to the continental United States for observation. The same rule of public proceedings applies in a military commission as it does in a court-martial of a service member or in federal court. We have the same rule. The public and the media can go in and watch the proceedings, but they can't record them. Can't take pictures. You can have a sketch artist sketch them, but within our criminal justice system, it's our way of balancing fair press, fair trial, free press, and in some senses national security and protection of information. That's how we've balanced that in our criminal justice system. We don't televise our federal criminal trials, nor do we televise military commissions proceedings, but you can observe them. And because it's hard to get to Guantanamo, a compensating transparency measure has been to have the proceedings transmitted, closed circuit, to an extension of the courtroom, stateside. And that's been happening since last fall. There is also a website where you can see all of the pleadings, all of the motions that have been filed, the court rulings, the reply briefs that counter the motion that a party has made. And then there is a transcript of the proceedings. It's an unofficial, unauthenticated transcript at this point, but a very quick transcript is produced, put up on the web verbatim. So you can follow, if you didn't get a chance to see the proceedings, you can go on the web and see what happened, word for word, through the proceedings. And those are important measures of transparency. And then I spoke of unbounded. All right, this is the criticism that of being concerned about expanded military jurisdiction. The mission of our military is to fight our nation's wars, defend our borders, not to police our streets or hold the trials that enforce the laws. And to embrace this military tribunal is to undercut that important value. That we need to have our civilian juries trying these cases so that our society gets skin in the game. Again, the jury being a major institution of direct democracy and linking the government to the people. And that if you substitute in this military court, that you're undercutting that. And there is a long line of distinguished cases in our Supreme Court's opinions going back to Ex parte Milligan, which was the trial of an Indiana man by military court when the civil courts were open. There's a distinguished line of thinking and dissent against military jurisdiction. And the response to that is, first of all, we have not sought this out. There isn't somebody trying to expand military jurisdiction out there. You know, I'm an officer who was plucked from Afghanistan thinking I was going to another operational assignment. And because I have legal training, they said, Martins, you know, you're on orders. You go do your job. We don't lobby for missions. We didn't lobby for this one. But if we're given the mission, we're going to do it with integrity. We're going to do it with skill. We're going to do it as well as we can do it. We're going to use from across the government every bit of expertise we can get. There are 8 U.S. Fabulous, tremendous Department of Justice attorneys who work for me, and the Federal Bureau of Investigation is mobilized to assist in investigations. We're using the whole of government, but we're going to use this authority of military courts because it fits certain types of cases. And our jurisdiction, the other part of the counter to this notion that it's this unbounded thing, is that look at our jurisdiction. Congress has very clearly circumscribed it to things that happen in the context of and associated with hostilities. That's an element of every offense that I have to prove beyond a reasonable doubt, is that it took place in the context of and associated with hostilities. It's not a peace, in an area of peace that you use this. That it is circumscribed to unprivileged belligerents, those who are not carrying arms openly. So it doesn't apply to other types of individuals and to uniformed soldiers, and it doesn't apply to U.S. citizens. Those all have to be in civilian court. And then it has to be one of those 32 offenses. So a circumscribed so-called subject matter jurisdiction. So confined jurisdiction involving officers and personnel, people doing it, who are trying to do a job that may have become too political, for whatever reason, is not able to be done in a civilian court. And the major reason cases can't be done in civilian court in many respects now is that Congress has blocked it. You know, you've got 2 of those 5 acts of Congress that I mentioned were National Defense Authorizations Acts, in which the Congress has said no detainee from Guantanamo can be transported to the United States with any federal appropriation. So I would say in that context, this is not an unbounded project at all. This is a project that is intended to implement the rule of law, and that to not see that and to not support it, I'm actually asking those of you, I'm the most unlikely possible spokesman for this. You know, I'm a former infantryman lawyer on my last tour of duty in the military with, as my wife likes to say, the definitive face for radio. You know, here I am trying to explain to folks that we're going to do this fair. We're committed to doing it fair, and it can be done, and that to not get behind it now, that there's been this resounding, all 3 branches of our government having weighed in, given the threat that we face, is unwise. So that's to stimulate a little discussion. I think we still have a good full half hour for questions. So why don't we go ahead? Let me start. What I'll do is I'll kind of just start here and go clockwise.
Major David Pate, I'm a student here. One of the big criticisms is that although it's wonderful that we're giving these protections to detainees, that this only applies to detainees who are alive, and that you're asking the military to reach an impossible civilian standard of proving guilt, and the response has been since 2009 to kill, not capture, particularly through drone strikes. And I just wondered, what's your response to that criticism?
Well, thank you, David. I think you raise an important point. I would push back on your statement of what our policy is. Our policy is to defend the United States, and we're going to use all instruments of national power and authority to do that. The Supreme Court calls it in a number of cases incidents of war. When you have an authorization to use military force, as we do, you can use different tools than the historical tools. And now I'll talk about it in terms of the Supreme Court, but this makes sense from probably a student of Clausewitz in military theory too. You can target your enemy. Those who are military objectives, your enemy, you can target them. You can surveil them, try to listen into what they're doing. You can detain them. Very important incident of war. The Supreme Court agreed with this in Hamdi v. Rumsfeld as to the current conflict in 2004. They said, even though you don't see the word detain in the authorization for use of military force in 2001, detention is an important incident of war. Also, an incident of war is to hold somebody accountable by trial under the law of war. Long-standing incident of war. And to agree with you, with the thrust of your statement, I'll say, and thank you for asking a question because you're helping me put a finer point on this, is if you take away one of these incidents of war, one of these methods of trying to subdue an enemy, and in our case, and in modern conflicts, you can only be righteously at war if you're doing it under a rubric of self-defense. We're defending ourselves against a threat. If you take away one of these ways of prosecuting that conflict to bring it to as swift an end as possible, you create distortions in the system. So if you deprive a soldier of the option of detention, think about this. I mean, this is a good visual, right? You have a soldier or Marine in Helmand, Afghanistan, and he doesn't have a system of humane detention where he can pass this individual off and know that the individual is going to be treated humanely under the law of war. If you don't have that option, but you do have the option of still attacking and killing, we are putting young soldiers in a very difficult position. As my previous boss would say, we are encouraging people not to live our values in that situation. So I would agree. I happen to be, I'll talk because I'm not here to talk about other policies of the government, but I'm talking about military commissions. I am high on trials. I believe trials are an important way to vindicate our values. They also give you a form of detention that is the most defensible and lawfully sustainable that we know. Although you can detain under the law of armed conflict, again, Supreme Court, Hamdi v. Rumsfeld, 2004, the most sustainable legal form of detention is incarceration after you've convicted somebody of a crime. This is recognized everywhere, that if you convict somebody appropriately, properly of a crime and marshal the evidence, prove it, and then they have a sentence and are punished, that is a form of detention that is going to stand the test of time. The Supreme Court also said in Hamdi v. Rumsfeld that once the conflict starts going away, the authority to hold them, just detain them, will unravel. And that makes sense. Your justification is going away to hold them. It won't happen if you've convicted them under a crime. Okay, so I believe that trials are important, partly because they ensure that balance between the different tools and the incidents of war that we have to be relentlessly empirical and pragmatic about using. Within that space defined by our values, we ought to be using all of the tools available to us. And trials, under law, are one of the most important ways of doing that. And we're dealing with an enemy that is fighting in ungoverned terrain, hence making a strike by drone into an area where the local government may be unwilling or unable to do so. We are dealing with a so-called asymmetric threat, and I would propose to you that holding somebody accountable under law is maybe the most effective asymmetric counterthrust. I mean, you're using all effective methods in war are asymmetric. I mean, the most basic flanking movement in a tactical engagement is happening asymmetrically in a way that the other side doesn't see. All effective techniques are asymmetric, even if you're surrounding with a bunch of different ways, you're overmatching an enemy. The law overmatches those who are flouting the law because it can provide a legitimacy that the enemy just can't match. And this is why we can't ever depart our values. These are not luxuries. The rule of law is not a luxury, and we've got to use it. It is the ultimate asymmetric weapon. Anyway, that's a great question. Let me go here.
Hi, Mike Weber. I'm a student here. I was wondering if you could talk a little bit more about the defense teams for the detainees. Mm-hmm. Specifically, I know a lot of them have civilian lawyers as well who are trying to do litigation in the civilian courts here. And so I was wondering, in the trials at Guantanamo Bay, are both the civilian lawyers and the military counsel that they're given, are they interacting together? Is there one who is in charge, or how does that?
Sure. Let me address that. That's a great question. Since the Boumediene v. Bush case of 2008 that went to the Supreme Court, detainees have had the right of habeas corpus. So they've been able to challenge their detention in civilian court. This is the age-old writ. It is in our Constitution. It is the one provision of the Constitution that our courts have clearly held does apply in Guantanamo. So many of the detainees have civilian lawyers assisting them in habeas petitions. So this isn't a criminal proceeding. This is actually a civil proceeding conducted under the rules of civil procedure in our federal courts. And they're all centralized here in the federal D.C. District Court here in Washington. And they are determining whether or not there is authority to hold a detainee. So I've been talking about criminal law, criminal trials, right? These are civil proceedings where a civilian lawyer is on behalf of the detainee filing a writ, petitioning for a writ of habeas corpus from the court. And the court is supposed to determine, hey, government, what's your authority for holding this person? And the standard is a standard that has been in place since March of 2009, which restates this law of armed conflict principle that I gave you, which was you can hold somebody if they're a combatant, if they're a belligerent. And it is this individual part of, or did he substantially support Al-Qaeda, the Taliban, or associated forces engaged in armed conflict against the United States or a coalition partner, including those who've committed a belligerent act or directly supported hostilities in aid of such forces. That's the standard. And they have civilian counsel to do that are often pro bono, or often doing it out of their interest in civil liberties. Okay, now on the criminal defense side, I mentioned before, right to counsel, and that is a detailed military counsel. That's a judge advocate who is trained in the law, practicing or is certified and qualified by one of the judge advocates general, but is somebody who's got a law degree and has been admitted to practice in the bar of one of the states. That person and has been trained to be a defense counsel. That's the counsel they're entitled to as of right. They also could go get another counsel, a civilian counsel, who may do it by pro bono or if the individual can fund it. And then if they are facing a death penalty case, they get a capital counsel, capitally qualified, so-called learned counsel. And different accused down there have had teams of lawyers. It hasn't just been one. And there is the detailed military counsel, or two. Some defendants get 3 or more military counsel. It could be a very complex case, a lot of discovery material, a lot of charges. The chief defense counsel, who's a Marine Corps colonel at this time, again, senior judge advocate, supervisory judge advocate for many years, very qualified person, is picking that team. He will detail one of the counsel to be the lead military counsel. Often in cases where you've got a seasoned and experienced civilian counsel, internally that team may make the civilian the lead for a number of pieces of it, have the civilian be the one leading different pieces. And that's up to that team on how best to represent the client, and of course it's up to the client. The client can designate who he wants to represent. So that's kind of how it works. And they are entitled to investigative resources and other things to help them mount a defense. These things get litigated. I will be the last to say that a defense counsel who would be standing up here talking to you would say he or she's happy with the level. And that is healthy. That you'll see that in every system. But I believe if you look at the resourcing and you look at the litigation of this that's happened in some of the cases where the judge has decided some of the requests for additional translators and investigators and other things, that you would see that there's a robust resourcing of the defense function. And oh, by the way, all those choices, right, are reviewable by the Supreme Court, ultimately, reviewable by the federal courts, so they're preserved on appeal. If someone thinks they're not being fully represented by counsel, not effectively represented, that is subject to review. Great questions. Okay, here.
Hey, General, my name is Mark Beadle. I'm one that's here.
Oh, hi, Mark. Yeah, good to see you.
Nice to see you. Recently in Pakistan, a senior LAT commander filed in court for protection against the United States government. And looking sort of the future of the asymmetric threat and our advantages with the rule of law, do you think that could be a successful strategy emulated by future commanders? And how would we plan to address that?
What specific strategy of the commander? I know the idea of filing in court.
Yes, sir, I'm sorry. So this particular LAT commander filed in a Pakistani court for petition to have the Pakistani government protect him from attacks against the United States, from like drone attacks and stuff like that. I kind of thought that puts the U.S. government in a pickle because we're going to have to take some risk in the political sphere or take some risk in the military sphere by letting this guy go. And I was wondering if you think that will be emulated by guys in the future.
Well, no, I mean I think certainly that could be a strategy of Anwar al-Awlaki had his father filed a petition in U.S. federal court. There's a famous decision there by Judge Bates. I would say it does present issues and difficulties. These are another aspect of this type of litigation, whether it comes in federal court, a prosecution in federal court or in military commissions, that you're dealing with evidence and events that are happening overseas. So it implicates our foreign relations in a very deep way. And a veteran of policy in the Department of Defense, know this well. And we were working together last year on rule of law in Afghanistan and overseas. It implicates delicate and difficult concerns in foreign countries that really aren't analogous to a regular civilian criminal trial of someone here. And so I would say, yeah, it does raise issues and difficulties. And if it's an increasing strategy of individuals who are harbored in different areas, that it'll present a challenge, but not in a totally different way than something we've already encountered, because that's the nature of this kind of conflict and the nature of this kind of prosecution. Any others here? Sorry, and then I'll, okay.
Chaplain Peter Lawson, Army War College fellow. Just had a question. If there's a debate between whether to utilize a military tribunal or a civilian court, who is the decision maker?
Oh, very good. There's a very good question. Yeah, there's a 2009 protocol between the Department of Defense and Department of Justice. And the ultimate decision maker is the Attorney General. So all the cases I've received through a decision of the Attorney General of the United States. And there's a process laid out in this protocol on how that's done. And it looks very much like, in terms of the rules that are used, the decisions that are made daily between two different jurisdictions that may have concurrent authority to try somebody in our courts, right? In fact, very familiar with this as a judge advocate trying cases in Fort Campbell and Fort Bragg, where we had a case that could also have been tried by the civilian courts, and we had to decide who was going to get that. We had a memorandum of understanding, still do, with the Department of Justice on who's going to try these cases. There's this protocol that covers it, and it uses strength of interest factors. You know, who investigated the case, what are the charges that could be brought, and what are the punishments for those charges? Where did it take place? You know, sometimes that's important to deciding which jurisdiction will do it. You know, are there laws that bar you from doing it in one or the other? And that's very important now for military commissions. So there's this protocol that decides which of two jurisdictions will get it. And again, you may have a drug case that crossed state boundaries between Oklahoma and Kansas, and you'll have two U.S. attorneys deciding who's going to do it. And they use much the same kind of analysis. It is, importantly, case-specific. It's very fact-oriented. And the intent is to do justice and hold accountability under law. But that's a great question. Ma'am, I'm sorry to keep you waiting. Yeah, go ahead.
I'm the justice reporter with the AFP, and then I'm covering Guantanamo on a regular basis. And speaking about criticism,
yes.
There are motions challenging the secrecy, and especially on the 802 conferences, and also challenges about the classification of the accused. Declarations. So is there any hope that something change about that? Is there any hope that the lawyers obtain an outcome?
Well, I'm not. First, I think you may be talking about specific motions, which I won't address. I'm not going to address any specific case, but I can talk about rules that I think bear upon this. Okay, and again, this is all going to be teed up for methodical resolution through a process that will all be preserved on the record, can be appealed to ultimately, federal civilian court, appellate court, and the Supreme Court. So that's the context within which these disputes and these concerns about transparency and any other issue and challenge to the commissions will be resolved. But let's talk a bit about it. This goes to this what I called unknown. These are unknown commissions, and they're not transparent. We are using the same information practices and protection practices we use in our federal courts. Okay, so I'm not going to promise that everything will be publicly available. There really are sources and methods and items that have to be protected. By the way, it's not just national security information. The government has a lot of information about individual citizens that we are not at liberty to just open our books to the media or to a party in a criminal proceeding. We have to have, I call it, enumerated authority to do anything with information in the government. That's what people expect. Someone may have a sensitive medical file or information. We don't just open that up and show it. So it's not just national security information I want to point to. Our values require, as do our laws, that we protect information as a government, and we do it carefully. Transparency, as a general rule, yes. The Supreme Court said in the Richmond newspaper's case, an open society does not demand infallibility of its institutions, but it is difficult for them to understand what they are prohibited from observing. We do have a desire to actually see the decisions our government is making. So very important approach to openness and transparency. If we're going to not have something be visible, and you're speaking of an example of a say, a pretrial conference between the two parties and a judge, which, by the way, we do this under Rule 17 in the Federal Rules of Criminal Procedure. Courts do this in federal court as well, where you're trying to set up the trial and administratively go through areas. You're not making any decisions on matters of law. You're not litigating anything. That ought to be done on the record. But and any decisions, even about administrative matters, need to be recorded then on the record, summarized for the record by the judge when they get back in. So, I mean, there is some level of something that the public's not seeing, but both parties are there to object to it. Anything that is actual litigation on an issue, it has to be on the record. So, we'll certainly see how those types of challenges come up in the future and they're resolved by a judge, but I'm not sure I see the tension with true transparency and understanding how the government's making a decision. Anything important has to be on the record, but we do all kinds of administrative things, and they're not being done ex parte, right? Which might raise a concern. They're being done with both parties there. They're able to watch each other. There's someone watching, and that's an important principle. If there's going to be non-disclosure, the commitments our government makes, and these are all enshrined in the procedures of military commissions, are that there has to be an overriding interest and reason for not having it be visible. So the protection of sources and methods, I would submit to you in cases, is an overriding reason. The protection of individual privacy on matters that really aren't material to the case, overriding interest. It has to be done in a tailored way. Okay? You can't use a blunderbuss instrument. It has to be surgical, right? As narrow as you can make it. You have to have looked for alternatives to the closure. Sometimes you can protect the information in a tailored way. And then you have to put it on the record and preserve it, right? So these things are any of the non-disclosures of information that a detainee may say. Detainees have access to classified information. That's what CSPA is intended to protect, is before they can blurt it out, we have to know they want to raise it, and then we're going to figure out how we can protect the information while also protecting his rights. You've got to lay that out in a way that can be reviewed. And even the case of the conferences, the pretrial conferences, again, which a lot of courts do, all courts do, that is being preserved as an issue through the motions practice. They can raise the issue if they want, and it'll be litigated. So those are the commitments on the use of information, that we have to reconcile this notion of a free press and people understanding how their governments are making decisions with these other important governmental interests. They're not always in sync together and together in interest. But great question. Ma'am. I'll come back to you, ma'am, but let me go here, and then we'll go to you, ma'am.
General, good to see you. Rosalind Jordan with Al Jazeera English.
Yeah, good to see you again.
You talked about the idea that this is one of the tools when fighting an asymmetrical war. You've also been noted for your ability to try to break the backlog, as it were, of cases at Guantanamo. Do you ever anticipate that there will come a time where this particular form of the military commission would no longer need to exist? And if not, why not?
Well, I will go, thank you. I will go back to this idea that although most cases I would submit international terrorism cases should be tried in a federal civilian court, there is a category of case where this instrument, which is now an act of Congress, is going to be the best available option. I don't see any major ending of this asymmetric type of threat. I tend to think that's the way people are going to try to strike out against very capable armed forces of a state. I think you're going to have stateless but coordinated efforts. I don't have a crystal ball, but it just seems to me that we're going to have those kinds of threats for a long time to come. And again, not existential in the sense that our everyday existence is threatened, but very, very serious in a way that sometimes even existential threats are less serious, because you get defined in how you respond, don't you? And you get tempted. these kinds of actors who are flouting the rules encourage even peaceful peoples to respond outside of the law. So having lawful instruments, and this is an institution that for over 200 years has been at the intersection of law and war. Having institutions like my office, that our team came up with, is Justitia ad ruptorum, justice at the breach. This is a notion in inherent tension. As you're in an area of war or armed conflict, how do you apply law? Well, I happen to think that applying law in those areas is a valuable instrument of our national power and authority, and that it can be useful in specific cases. Don't want it to be unbounded. Don't want to turn soldiers into our civilian court system. But if given that mission, that we ought to be able to do it. So it's a law on the books, and it's an institution on the books. We are developing a specialized practice, where we're able to handle large amounts of classified information safely. We have the clearances, we have the compartmental facilities. The Defense Council have those. We have the ability both to do justice and to protect information. We have relationships with agencies and organizations all over the government, increasingly with international partners. That specialized practice as an institution is a valuable thing to keep going, not just by its own momentum, but you can see if there is a need for it to keep that going. And that even though the number of cases may be small, the national interests vindicated could be hugely important, justifying the expense involved in that. So, Congress has invested a lot of legislative effort in trying to pull this together in a way that's consistent with our values and that does justice. My sense is it'll be here. And again, 2 different presidents. The Attorney General last month at Northwestern has said that this is an important part of our national security and justice institutions. Let me go over here. One more question. Ma'am, you have the last question.
Rosemary Reed, I'm with DC Historical Society. I was struck by listening. I know today's focus is detainees and international and serious crimes, but it seems to be your average soldier crime would be, I'm going to say, local. Why aren't they judged by a jury of their peers? Why is it always officers? I was struck by that.
Well, I mean, this is the jury function, the fact finder that Congress has decided upon in these courts. Now, you are pointing out the military justice system since 1950 has included up a third. If a enlisted man seeks a jury trial under the military commission or the military justice system, he may elect to have jurors include up to a third enlisted soldiers, non-commissioned officers. But this is the composition of the boards and the juries that Congress has specified, and that's what we're seeking to implement. I would submit to you that it is an impressively diverse group with gender diversity, racial diversity, all these different things that are policed by our Congress. Does not include enlisted personnel, because that's what Congress put officers in the pool. They put the officers in the jury pool. Perhaps, policy reasons why that might make sense. Officers are going to be in the force for a while, not going to necessarily be up. Their enlistment isn't necessarily going to be up. Some of these cases can take a long time because they are very complex international cases. So there are reasons why Congress could legitimately, reasonably decide we're going to have the jury pool be this 230,000 person set of officers. But it's a very good question. And I encourage people to do that kind of comparison. Comparison is very helpful in this, because the systems are not identical. And in fact, the differences between the systems may, in a particular case, make it a better forum. But by looking at something you know and are familiar with and trying to analogize, often you can come to a sense of the system. And then you've got to step back and look at the entire system and say, is it a fair process that is getting at the truth but doing it in a way that it lives up to our highest ideals? And my final point will be that doing so and trying to find out what happened in an event, even something that we think we know a lot about, looking at it from the point of view of accountability under law and seeing if specified charges can be proven to the highest standard known in our system and then recorded so that other people can look at it and see, was it fair, that is a valuable function and an important justification for this process. Thank you.
Ladies and gentlemen, I just wanted to add one little note about General Martins, and that is that he did not seek this particular position, but in order to ensure that this job be done with a certain level of continuity and optimal professionalism, he requested that his tour be extended so that until I think it was November 2014, and in doing so, he voluntarily gave up the possibility of having another appointment and a promotion to a higher rank to Major General. This is an extraordinary personal sacrifice that has been done in the interest of ensuring that this job be well done. And I just wanted to just make a comment here about this. This is a model of the type of service to a cause higher than oneself, which is one of the central lessons of moral leadership that we here at the Institute of World Politics try to inculcate and encourage in our students. There are so many people who are worried about their careers and worried about their position and their corner offices and their personal power, and to have officers like the General do this kind of service is really the height of civic nobility. And I just want to thank you for embodying this and for honoring us with your presence here and your outstanding presentation. Thank you, sir.
Sure, I've got something for you, but I've got it upstairs.
Okay. Well, let me. These are symbolic things. This is that I mentioned Justitiad Ruptorum. This is our coin.
Oh, thank you, sir.
And then I've got something here for you. I brought some of these back from Afghanistan. This was the cup that we used in 14 contested provinces of Afghanistan. Rule of law field support officers going to try to help build rule of law capacity in local and provincial Afghan institutions. We have these cups, John. I wanted to give you one for the command. It's a field cup now. You never have to wash it. Just rub it on your leg. But Afghanistan on the front. My favorite Afghan proverb, Pashtun proverb, that this institute embodies. Ya mamlakat bela kanun saka de zangal haisiatlari. A country without law is a jungle. And I wanted you to have one of these.
Thank you, sir. We're honored. Thank you so much. Fantastic. Thank you for coming, ladies and gentlemen. Have a great afternoon.